Your Honor, I wish the court to take judicial notice of the raging war between Iran and the USA. The possibility of these Kenyans being killed is very high because America can be bombed anytime. So we cannot allow our Kenyans to go. Number two, Your Honor, on the question of being flight risk.
Do you have any interest?
No. Everybody is being found off guard, like the flood waters. Yes, Your Honor, number two, on the question of them being flight risks. Your Honor, America has proved that it can pick anybody. The president of Venezuela was picked. The president of Iran was...
Sorry.
What you're saying, wait, I've finished. I'm only saying...
Those things cannot be said outside an affidavit. So Mr. Omari can take time, go and prepare an affidavit and bring it to
I say the judicial notice. As I close, Your Honor, it is only fair, but there is no country that can, if these people are wanted by America, no country will take them. So they are here. That's it. They can.
Your Honor, let me start very quickly. Your Honor, I will not even tell you about the definition of what is compelling, because now that you know the definition, you know that they have done nothing about it. Your Honor, instances of cases, though I do not remember often, I'll give you I'll bring the copy. In the case of Dorothy Manju versus Republic, in the case of Susan Kaleki versus Republic, in the case of the Akashas versus Republic. All these matters, all the respondents were granted bond. I was lucky to have been in all those matters. In the Akasha case, when that time Chief Magistrate, Mr. Judiciary in Mombasa, now a judge, granted bond, the state, in its excitement and excesses, went to the High Court on review before Justice Moya. Justice Moya said there was nothing wrong with granting bond. Having a second bite of the cherry, they went to Justice Moreno Dero. In the same matter, Justice Moreno Dero said, bond is right, and it was granted. They went to Malindi Court of Appeal before Sichale, Okwengo, and Mahandia. The Court of Appeal told them, that matter is over. Bond was granted. So when the state comes here, they believe that these rights belong to them. That is how they come in. And they know very well, and I know Mr. Witt has read Article 19.3, he knows very clearly that these rights belong to an individual. So they cannot come to this court and tell you, and give you sweeping statements, and tell you they're likely to interfere with evidence, likely to abscond. Mr. Whitty, who is my very good friend, knows that the courts have made decisions on when you say somebody is going to interfere, you don't come and tell us likely. You must come and put material before the court. When you say somebody is absconding, you must put material before the court. Your Honor, that is the law, and I am saying, Your Honor, that is binding. Richard Alden versus Republic, Mr. Whitty knows it very well. The court, and that was Justice Lesit at that time, indicated that for somebody to say somebody is going to abscond, you must show that they have made an attempt or they have made a preparation. That has never been countered. It is the same case with Dwight Sagarai versus Republic, whereby this Justice Korir said you must place material before the court to show somebody has even bought a ticket. If you are going to say they are interfering in the same authorities, what have the both courts said? Anybody who interferes, first of all, it's a criminal offense. They can be brought to court for that particular offense. But in any case, if you are saying that they are interfering, you must also place that material before the court. That includes the case of Jackton Mayende versus Republic. So, Your Honor, when they are coming and telling you all these things, where is the compelling reason? They have failed. such that, Your Honor, please, Your Honor, and this is, I'll beg very humbly, and Your Honor, these people are very humble people. They are asking you, Your Honor, they will come to court, give us conditions, give us time, give us, the reason is to appear. They will be able to appear. They can deposit passports, they can report, they can always come. So we know that today, as you woke up with the right side of the bed, you are going to listen to us and understand that please breathe that life into that constitution. That right is important. Such that I'll just leave it to you and tell you, Your Honor, as you do that, you just read Article 20, 21, and 22, and 28, and you will realize that the state, as always, and this is in their DNA, you must fail.
Your Honor, I have
We split our time.
You are sharing.
Yeah, we split our
How
time.
many are remaining?
Of the 7 minutes, three and a half.
After 3. Yeah, so you have 3 minutes.
thank you, Your Honor. Your Honor, my duty is to demonstrate to the Honorable Court that there exists unusual and exceptional circumstances to warrant the release of the respondents on reasonable bail or bond terms. Your Honor, from the decisions that have been shared by my senior, Mr. Ombeta, the superior courts have considered this issue and arrived at the conclusion that indeed a look at our cell facilities do not contemplate the detention of a respondent for long due to the strained facilities that are there. For the legal status of the respondents before the Honorable Court, is that not of a suspect
Yes.
under the Kenyan law, and is equally not a convict? So much so that they cannot be remanded at the industrial area, and again they cannot be detained at our prison facilities. So because of the strain in the facility, the prison, the cell facility, it behooves this Honorable Court to impose certain conditions to warrant the release of the suspects or the respondents before the Honorable Court. Secondly and lastly, Your Honor, it should not also be lost to the mind of the court that the period through which the respondents will be detained in the cells will not be factored in at the time of sentencing, if at all, for argument's purposes, if at all they are ultimately extradited to the United States of America, their cases heard and convicted. So for that reason, Your Honor, now that you've been invited to limit their rights, their right to liberty, it is important that the court considers the less restrictive means under Article 24 of the Constitution, so that, Your Honor, we do not end up causing a miscarriage of justice. I rest by, with humility, directing the mind of the court to a decision made by the Court of Appeal. This is in the case of Abdurrahman Imram Juma versus Republic, decided by my Lord Makandia, Kamtai, and Agashoka.
Again,
Abdurrahman Imran Juma. Owiti was up, yes, Owiti actually, my colleague and my senior, Mr. J.V. Owiti, was among the counsel representing the state. The Republic. And their objection in this application, Your Honor, was dismissed by the Superior Court. I would have hoped, Your Honor, that you will have at least learned from this and posed very little objection in this matter. Your Honor, I must close by saying that the submissions made by my colleague, Mr. Owiti, appears to be one that is suffering from a hangover of the retired constitution. For the current constitution, Your Honor, does not perceive of any crime where a respondent or a suspect will be denied of their right to reasonable bail or bond terms. As it was held in the Court of Appeal decision, Your Honor, I will be requesting with humility that you consider releasing the respondents with reasonable bail or bond terms, so that if there are any appeals in this matter, would not end up causing a miscarriage of justice. That is all from me, Your Honor. Thank you.
I've heard all the parties on the two applications. The first application was on the preliminary objection and also on the bond. I reserve a ruling and I will deliver on the 17th of March. That's next week on Tuesday. And you can file your submissions by close of business tomorrow on the issue of preliminary objection for those who have not filed. Okay?